We will go on the record in the matter 25 CM 179, State of Wisconsin versus Christian Madison. The state appears to District Attorney or Assistant District Attorney Jose Villa in person. We have Mr. Madison in person without counsel. We're set here today in this matter for a status conference. I believe we were going to be in victims' rights compliance, and you were going to be able to present an offer or move from there.
Yes, Your Honor. An offer was presented at the last hearing we had on 10/8, and the offer was to do the DV class with Mr. Dave Hatch, reduce this to a DC for court costs, and dismiss but read in the crim damage count, but holding open rest.
All right, lock in, because this is one of those courtroom setups where the deal is actually better than it looks, but only if the defendant follows through. You've got a young guy, no lawyer, and the state is basically offering a lifeline. Take a DV class, get the charge reduced, and avoid a lasting record. But here's the catch. Restitution is still hanging out there like a storm cloud for 60 days. Question for you. If you were in his shoes, would you take the deal immediately or try to figure it out later and risk losing everything?
For a period of 60 days to accomplish that.
All right. Thank you for refreshing my memory. And we are in victims' rights compliance?
Yes, Your Honor.
Do we know if there is any restitution that's going to be requested?
Not at this time.
Okay. Were you able to do that class?
I made it to one session, and I just started my new job, and my grandpa drives a tow truck, so it's been a kind of a really big struggle to get to the classes. I was wondering if there's any way I could like set it up for like Washburn or something somehow, or I'm just now eligible to get my license back, so I'll be able to get back and forth easy now.
Well, unfortunately, you can't do it through the Washburn. It has to be through the Burnett County.
Okay.
But I'm okay as long as you talk to Mr. Hatch.
Yeah.
He's okay with extending it. You can let
Okay.
him know in the hearing. Judge said it's okay to extend it because I would rather have you complete that class and get this benefit because you're a young man and you don't really want to have.
This right here is the judge doing something you don't always see online, balancing accountability with a real-world path forward. Notice how the judge isn't excusing the missed sessions. She's saying complete the program properly and you get the benefit. That's huge because program compliance often acts like a gatekeeper for reduced charges. Also, no counsel means he's relying on the court to explain logistics clearly. Let me ask you, should courts offer more flexibility, like Zoom options, or does that risk people taking these requirements less seriously?
Yeah.
Record. But it is going to be important for you to try. And I understand wanting or needing to work with your dad and with the plowing and all of that, especially now. But hopefully you can figure that out. So I'm going to give you a little bit more time to be able to do that. But the first thing you need to do, call Mr. Hatch. Okay. And get that worked out with him because he's the one who's in charge of that class. So I'm going to give you a little bit over a month so you can see about doing that. How old are you?
I'm 22, about to be 23 in March.
Oh, you have such a baby little face.
Yeah.
I mean, that's a positive thing. It'll get you far in life. So do you actually tow with your dad? Or not tow, but plow?
No, I've been working at Jacqueline. Sometimes, well, he does tow, but sometimes I'll go with the help. But not lately, really, because I've been working so much, working 12-plus-hour shifts.
Well, Jack Leagues, that's a great place to
Oh, yeah.
too. What's your normal work hours?
3 to 3:30 a.m. So,
Okay, that's a long shift.
yeah.
3 to 3:30 a.m. And so you're going to need some sleep. And do you know how to use Zoom?
Yep.
And so if you're able to call in, can you guarantee you're going to be in a good Wi-Fi or internet spot?
Yep.
Why don't we I want to give you a little bit of time to sleep. And you said you start at 3?
Yep.
What about 2 o'clock on January 21st? You can call in on Zoom.
This is a smart, practical judicial move.
She's not just setting a date, she's engineering compliance. The court recognizes his brutal work schedule and offers Zoom so he can still meet obligations without crashing his job. And here's the strategy point. When a judge gives you a clear step-by-step roadmap, call the instructor, complete the class, provide proof, that's your golden ticket. If you ignore it, the court's patience usually evaporates fast. Do you think his schedule is a valid excuse, or is it still on him to make it happen no matter what?
Okay.
Okay.
If you've completed the class by then, maybe you will have completed the class by then, you wouldn't need to come in to that next hearing, but you need to get that, make sure that the state, that Mr. Vila has the completion, because he can take care of it by paper.
Yeah.
The only thing that'll be outstanding is that restitution. And so if they're seeking, if the victim is seeking restitution, you'll get a notice and we'll have to have a hearing.
Okay.
Okay? So 2:00, January 21st by Zoom, okay?
Yep.
So you can come up here and get your notice and you're free to go.
All right. Thank you.
Heard in the matter 25 CM 180, State of Wisconsin versus Richard Connors. The state appears through Assistant District Attorney Jose Vila in person. Mr. Connors appears in person without counsel. We're set here today in this matter for a status conference. Is there an offer that can be?
Notice the pattern. Same courtroom, same prosecutor, and again, another defendant without counsel. That matters because when you don't have a lawyer, the court will explain procedure, but it won't advocate for you. Also, status conferences are basically the decision point hearings. Take the offer, negotiate, or set the case toward trial. In real life, most cases are won or lost right here, not in a dramatic trial moment. Let's see if this next defendant understands what he's doing, because it can go sideways quick.
Presented?
Yes, so the offer that was presented again at the last status conference on 10/8 was for Mr. Connors to obtain an AODA assessment, and this would drop down to a disorderly conduct for court cost only.
I don't know if you got the message, but I called down and let Smith's office know I was going to do a motion for discovery today. And
That is,
You do not wish to accept the offer?
no,
Okay. So he doesn't wish to accept the offer, so you need to, it needs to be in writing, what you're asking for in the discovery. You need to file it. Well, you need to give it to the state in writing, okay?
where would I turn that in at? Just right at
To the state. You can file a copy with the court and you can hand deliver one to Mr. Vila or to his office.
okay.
and discovery is waiting for you whenever you do that.
This is the DIY defense moment, and it's risky. He's rejecting a deal that would reduce things to disorderly conduct with court costs, and instead, he's going for discovery like he's about to out-lawyer the system. But the judge is clear. Discovery requests must be in writing, served properly, and handled through process, not phone calls and "I told someone's office." That's the difference between being heard and being ignored. Be honest, is he standing up for himself or accidentally walking into a procedural trap?
So you can probably do it, he can probably do it today.
He could do it today. It's ready for him. He just needs to pay and pick it up.
Okay, how much, do you know how much?
It's $15.
$15. So you have to pay for it when you get it. So you could even, if you have $15 today, you can even go and get a piece of paper and pen and write that that's what you want to do. You can give it to the state and pay the $15 and you'll be good to go today.
Okay.
Okay, so what I need to do then is set a status conference because it looks like this is going maybe down the trial track.
Possibly.
Is this your?
This is my case, Your Honor.
Oh, right. So I'm going to schedule you for 11:15 on January 5th, 11:15 January 5th. That gives you a month, so you'll have the discovery. Do you have $15 today?
Yep.
Excellent. So you'll be able to look at all that discovery, do all of that stuff, and come back on the 5th, and then I'll know if you want to continue or you want to negotiate with Mr. Vila, okay?
All right.
Come get your notice and you're free to go.
I'm sorry, Judge, I missed that. When was that?
We will go on the record in the matters 25 CT33, 25 TR 492 and 493, State of Wisconsin versus James Lightfeather. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lightfeather appears in person with his counsel Nicholas White by video conferencing. We're set today in these matters for status conferences. Mr. White, please update the court.
Thanks, Judge. This is a case that is going along the IDIP process. Mr. Lightfeather saved up some money for an AODA. He has that scheduled for next Tuesday at Superior Treatment. He has had contact with Tessa for the IDIP. I think he just needs to do the assessment and kind of formalize the IDIP agreement or contract.
Excellent. I'm glad to hear you got all the money saved. You got it all lined up.
Yes, it's been trying, let me tell you, man. Where I work at, the company shut down as of December 19th. So I've been there 2 years, and they just all of a sudden just closed it down. So
it's closed for good?
down to December 19th. Yep.
This is where the courtroom becomes very human very fast. He's doing the right thing, saving money, scheduling the assessment, working the program, then life punches him in the face with a job shutdown. And the judge's tone shifts immediately because compliance isn't happening in a vacuum. It depends on stability, income, and logistics. Still, the key legal reality remains. The court can sympathize, but deadlines and program steps still matter. What do you think? Should courts give more grace when someone loses their job, or does that create unequal outcomes?
So I gotta find another job, which I will.
Mr. Lightfeather, I'm so sorry to hear that. I have been so proud of you. I mean, these are allegations and these are not great allegations, et cetera, et cetera.
Sure.
However, but I've been so proud of you in how you've been rebuilding your life and becoming more stable and responsible.
Yeah.
And
the life
so
I used to live was
not
not good. No.
And I'm so sorry to hear about the closing of your job because you were doing so great. I know you're going to find another one.
Yeah.
You're going to get right back on track.
Where?
I'm very hopeful. What I'm going to do is I'm going to schedule you a bit out. How about that February 2nd at 1:30 date?
That makes sense.
Just to get a status to see where you are. Mr. Lightfeather, for a status there, if you still need things to do to complete it or whatnot, you can appear by telephone, so you don't have to drive from Superior to get here. Or you can do Zoom if you figure that out or know how to do Zoom. So we'll do February 2nd at 1:30. You can come get your notice and you're free to go.
Thank you.
Thank you. Mr. Natanoki?
The Zoom instructions on there for you.
We will go on the record in the matter 25 CT46 and 25 FO 293, State of Wisconsin versus Skylar Natanoki. The state appears through Assistant District Attorney Jose Vila in person. Mr. Natanoki appears in person with his counsel, Mr. Nicholas White, by video. We're set today in this matter for initial appearances. Mr. White, were you able to go over the criminal complaint with Mr. Natanoki?
Yes, I was, Your Honor. I did have a call with him yesterday. We went over the complaint. I don't think I realized that there was a forfeiture tracking along with it, but I did talk about the CT file with him.
All right. And so he understands charges and the maximum penalties?
That's right. We can waive further reading there. I'd enter a not guilty plea for each count and then including the forfeiture.
Not guilty pleas will be entered on your behalf on all matters. You will be entitled to a jury trial, and you would be entitled to a speedy trial should you request one. The forfeiture, Mr. White, is an underage drinking possession, 17 to 20, as a third offense. And as you're probably aware, or as you are aware, and so is Mr. Vila, those are matters that the legislature doesn't give much.
This part is quietly brutal. No wiggle room means mandatory rules tied to the charge. Even if everyone in the room wanted to cut a deal, the statute limits negotiation, especially with repeat underage alcohol offenses.
Also, notice the judge carefully explains rights: jury trial, speedy trial, not guilty pleas entered. That's due process in action. And when a case has both criminal counts and a forfeiture-style violation running alongside it, the defense strategy becomes a chess game, not checkers. What would you prioritize first, fighting the criminal case or minimizing the mandatory penalties?
Wiggle room to negotiate with. So that's what that is, but a not guilty plea will be entered on his behalf with regards to that matter. And then perhaps that can all come into play as we work towards a resolution. Are you going to be looking at doing the IDIP program, the Intoxicated Driver Intervention Program?
Yes, I would like to.
And I'm not sure of the cost on that, but Mr. Vila can give you a pamphlet right now. Please contact Ms. Tessa Anderson as quickly as you can to enroll in that program, because by doing the program, you would be able to get benefits such as if you have, with a mandatory minimum here, this mandatory minimum for an OWI second is 5 days of incarceration. You'd be able to do that with house arrest, electronic monitor at your cost, okay? So there are benefits like that. So look at that. What I can do is schedule you for the February 2nd at 1:30 return date. You're gonna let me know that you're in the program or et cetera, and then we'll know where we're gonna go from there, okay?
Okay.
All right, you can come up and get your notice. Anything else, Mr. White?
No, Your Honor, that was it.
All right, anything, Mr. Vila?
Not from my perspective, Your Honor.
Thank you, then we are adjourned. We will go on the record in the matter 25 CF 127, 25 TR 780, 837, and 838, State of Wisconsin versus Michael Eads. The state appears through Assistant District Attorney Jose Vila in person. Mr. Eads appears in person with his counsel, Daniel Chapman, by video conferencing. We're set here today in these matters for status conferences. Mr. Chapman, please update the court.
Your Honor, we're prepared to waive the preliminary hearing outright today and go to arraignment if the state is ready. And I'd ask that all of the traffic tickets be entered a not guilty plea if it hasn't been done so, and track along with the criminal case.
Do you understand what it is to have a preliminary hearing, Mr. Eads?
Yes.
Your attorney thoroughly went over that with you?
Yes.
Do you understand that the state has the burden to prove a felony was probably committed and probably committed by you?
Yes.
Do you understand that if you waive that right to a preliminary hearing, you are agreeing the state can at least meet that burden?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you, would be able to produce evidence on your behalf, or possibly discover things about the case, which could include defenses. But for this hearing only, you're giving up those rights?
Yes.
Do you understand that if the state does not meet its burden at the preliminary hearing, I could reduce a felony to a misdemeanor or dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
I will find you are competent, you're freely, intelligently and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila?
Your Honor, the information has been filed and it mirrors the criminal complaint.
Does proceed with the arraignment, and does he understand charges and maximum penalty?
He does understand the charge and the maximum penalty and the minimum penalty. We will waive reading of the information and enter a plea of not guilty.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Mr. Vila, is this your case or Mr. Smith's?
This is my case, Your Honor.
I could do status conference block of January 21st at 9:45 or 2:15.
Either of those also work for me.
How about January 21st at 9:45?
Thank you.
We'll have a status on that date and time. You can come get your notice and you're free to leave, okay?
Thank you.
All right, thank you. Thank you, Mr. Chapman. We are adjourned.
So here's the big takeaway from this courtroom run. The system keeps offering off-ramps, but only for people who actually follow instructions. One defendant got extra time to complete a DV class to protect his future record, with restitution still looming. Another rejected a reduced offer and chose the discovery route, meaning the case may drift toward trial. Then we saw how treatment programs and structured timelines can keep someone on track, while mandatory minimums and no negotiation statutes can hard limit outcomes. Now I want to hear from you. Which defendant made the smartest move today, and who's playing with fire? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.